Hello, Uganda. Good evening and welcome to the show On the Spot. My name is Patrick Kamara. Now, today, Buganda Court Magistrate Winnie Nankya declined to grant an order for the release of opposition politician Dr. Kizza Besigye. She said there is a similar case in the High Court which takes precedence as it holds more power than the lower courts. The court has also stayed the proceedings of Dr. Kizza Besigye and Samuel Lubega Mukaku for 60 days, recognizing that Besigye is unable to stand trial due to his current state of health. Tonight we'll be looking into this and the pronouncement of the Supreme Court. Let me introduce my panel this evening. I have the spokesperson of the NRM Caucus in Parliament and Member of Parliament representing Kagoma North, the Honorable Brandon Kintu. Thank you so much for joining us, Brandon.
Pleasure is mine.
We also have the Vice President of the Uganda Law Society, Asimwe Anthony. Asimwe Anthony, thank you so much for joining us. Good evening, sir.
Thank you for having us.
Let's come back into the discussion after this. Gentlemen, I want to thank you so much for having honored our invitation, and once again, a warm welcome to both of you.
Thank you.
Let me begin with you, Mr. Vice President, Uganda Law Society. Probably to you to be able to give us a better preamble to understand where we stand right now and the technicalities of the legal challenges Dr. Besigye is facing today. Because as a layman, I would thought probably Besigye should be somewhere in Kasangati walking free, but he's not. So lay the case for us as it is now.
Thank you, Patrick. Like you've rightly stated, Besigye should be somewhere in Kasangati or somewhere else, probably in hospital. When we received the Supreme Court ruling on the 30th of January, there was a lot of excitement. People excited that now everyone who is undergoing trial in military courts is going to be set free. There were so many issues to do with the interpretation of the ruling. It was received with, you saw the cheers and the jubilation on the streets. And of course, for people like Besigye and other people who are undergoing trials in that court, what they expected was probably the next day or the following week, I should be out of here. Unfortunately, that has not been the case. There are challenges to do with the ruling in itself, in as far as, whereas the Supreme Court was unequivocal saying civilians shouldn't be tried in the military courts, but at that time we have ongoing trials. We have people who are in custody who have been sent there
to the same court
by the court-martial, and that means the court-martial cannot continue handling these matters. Now, the challenge is now the process of how do these people get out of prison. Dr. Besigye, through his lawyers, tried all the necessary steps through the necessary authorities. Now that we have a ruling, we don't see why our person should be in prison. Now, unfortunately, like I said, it's a lot of procedurism. Okay, you had the Supreme Court say cases should be transferred to other courts, the civil courts. Now, that is a process that you do not just, carry a file and take. And in all the attempts that have been made by Besigye's lawyers have been frustrated in one or another. You saw us come out as the Uganda Society when we realized that these lawyers had filed applications for habeas corpus. The habeas corpus is where any person can apply to court to be produced. Actually, it's called produce the body, whether the person is dead or alive. And what the court is supposed to do is investigate the circumstances under which that person is in custody. If they're in custody, if they are brought, the question should be, why are they in custody? And the understanding was, because there's a Supreme Court pronunciation that civilians should not be tried in court-martial, that means right now there's no pending proceedings. There's no reason as why Besigye should be in custody.
If you could pause there, because he used two words that are very interesting, and one of them is that transferring the case to the civilian court. Does the court pronounce itself that now the case before the General Court-Martial is transferable to the civilian court? And does the court pronounce itself on whether Dr. Besigye has a case to answer or not?
You see, that's the absurdity with some of the, some of the rulings, some of the orders that are made. The Supreme Court fails to bring in that finality, leaving the doors open for such things were happening, that the things we are seeing now, the gap, the spaces that are left, taken advantage of to abuse further these people's rights. It should have been easy. It would have been easy for the Supreme Court to say all the people are undergoing trials, any trial in the military court martial should be released forthwith. Very simple. But now you're saying these people are given a leeway to transfer cases to other courts, so they are holding on to those people. I don't know, Patrick, if you're aware that any person who is held in custody, in prison, must have a remand warrant. A remand warrant is signed every time you appear in court. A judicial officer signs a remand warrant. You're being remanded to prison until such a day when you're supposed to be brought back to court. Now, unfortunately, the ruling is delivered on the 30th. Besigye is supposed to appear in that court on the 3rd, and the Supreme Court says this court cannot sit as a court anymore. Meaning on 3rd, the remand warrant has actually expired, actually on that very day of the ruling. So the question is, under what circumstances is prisons holding Besigye? That means this illegally.
But you see, you've just stated here that the Supreme Court did not give a finality on the issue. And because of that, whoever is having a case against Besigye can use that leeway, to technical or legal way, to continue what they are doing, and whatever they are doing which seems to be legal.
And like I'm saying, that is what, those are the challenges. That's the issue we're having right now. That was our worry in the first place, that with this kind of ruling and these orders we are seeing, there's going to be a likelihood of this kind of scenario. Now, the stage, this is Besigye who has someone, he's from the privileged point of view, where there are people, there are lawyers, the public is looking at him. But remember, there are thousands of other people. But now, sticking to Besigye, this application is made. First of all, even the court fixing an application becomes a problem. This is an application which was filed on the 4th of February. The Constitution, Article 23, Sub-Article 9, is very clear. Once proceedings, the habeas corpus application has been made, it should take precedence over anything else. In fact, court should first abandon every other business. They handle that because it touches important matters of a right to liberty, a right to personal liberty, which should be protected jealously.
Okay. The Honorable Brandon Kintu, when you look at what is going on now, and the talk, the pulse of the nation is now on Dr. Kizza Besigye, the Supreme Court pronounced itself, it looks like the government of Uganda, the executive, is locking up a man, trampling on his right, and yet it would have been very easy, transfer the case, not take very long, to a civilian court. If he has a case, let him answer for that, and if he loses, let him serve. Why has that been so hard?
Well, the case of Dr. Besigye and the Supreme Court ruling has also enabled some of us who are lay people, who are less knowledgeable about the law, but we have come to understand. I sit on the Committee of Defense and Internal Affairs, where the bill that has been withdrawn today at about 2 p.m., we have been looking at it. We had even organized a benchmark tour. So after the Supreme Court pronouncement, we had to withdraw because something that we were going to benchmark on, it was not necessary anymore. And it's good the Vice President has told us here, those are the same questions that we've been also asking. And somebody also popped a question this evening. Then now, how come that the DPP, they have referred, I think when the Deputy Attorney General was in Parliament, they said, we have filed the DPP for advice. Then you'd wonder now, under how does it come even to the basic of the little knowledge of law? You can try to assess this. So it has raised lots of questions. But you've asked, where is the executive? Now, as the other arm of government, which is Parliament, where I sit, tomorrow we are caucusing. The previous caucus we had, that was immediately after the Supreme Court pronouncement. Members of the caucus, who are also MPs, when we go to the caucus, it's not a parliament, but these are party members, raised this issue, how do we proceed? And that was the proposal that this UPDF Act of 2024 should be withdrawn. so that we can make adjustments in line with what the Supreme Court raised. And I want to assure you what is the government doing now is that tomorrow we task the Attorney General to bring, and the Minister of Justice and Constitutional Affairs, together with other stakeholders. I don't know, the Vice President may tell us, because we would also appreciate their input in this, because this is something that is concerning everybody. The three of us here can be candidates of the court-martial.
So you're saying tomorrow you have a caucus meeting and you're going to look into the UPDF? Specifically UPDF.
Specifically, actually.
But don't you run a risk of trying to caucus and end up making a law that is going to be in contravention of the Supreme Court ruling?
That is what we want to do. We have members of
That's
Parliament.
what you want to do?
No. We want to check. I'm telling you, we want to do something in line, actually, from the advice of the Supreme Court. I don't know whether in law that's the best word, but from the court, the Supreme Court ruling, we want, because they came up with recommendations, and this is a law for the people. I mean, literally, why would I don't have any gun, but if probably a bullet is found in my car, why would I be tried in a court-martial? We have serious cases. Let's look at Jamil Mukulu. I remember him when I was still in Jinja and Alfenya one was still, because that's my land. Jamil Mukulu was kept there. I've never had him being arraigned before the court-martial. But this is a guy who had a rebel group. So you would put questions. So this has been a landing mark. And I want to assure you that whatsoever we will do, it will not be against or beyond the Supreme Court. We simply want to align.
But what do you mean to align? Because the Supreme Court seems to have been very clear on the issue that civilians should not be tried
exactly.
in a military court.
Now
so when you say to align, what
it
exactly
should
are you
be?
aligning?
It should be in the law now, clear. We want to say that these political, we should put safeguards. Who are the people who are supposed to be charged? Because military courts, martial courts, they are elsewhere, all over the world. But how do they behave? We want also to look at the name. Do you get competent courts where a judge is called a chairman? So if you want to erase the name tribunal and to make it a court, we have put specific. Now that probably those, we had a very good discussion.
You know, the Supreme Court seems to have asserted that civilians will not get justice in a military court.
Exactly.
And for you to align, to align to what? Because the most important thing is justice.
You know, Patrick, we are both speaking vernacular language, because you are Mutora, I'm Msoga. Probably I'm using the word to try to justify what you should be understanding now. But we want respect. That's what I would say. But respect is not only by word. We need to put, for example, I heard that if you would be charged in a military court, it would be very difficult for you to appeal. The lawyer here will tell us. But we want also to put those safeguards. We did not know actually much. People were not making noise. They thought if you oppose government, you got the military court.
So you seem to suggest, Honorable Brandon, with all respect, that you're walking into this caucus tomorrow to legislate, well, at the caucus level, for the benefit of the people of Uganda. Is that what we should pick? Are you in this for good?
You should not even just speak.
You seem to suggest that you're in this for good.
I am speaking with authority because I speak for the caucus. So I'm telling you, we have only 2 items. But I want to tell you that amendment will consume.
Are your intentions for the good of Uganda?
Of course, that's why we are
the Supreme Court has been very clear
but there is
with the intention for the good of you and every Ugandan.
There is no problem every day. Surprising, last Sunday, I was coming from the shrine, there, the Matters Shrine in Munyonyo. When I came that roundabout that goes to Mulungu, I found a pastor and was telling me, Jesus loves you. It wasn't him. I'm from being reminded that Christ is the creator, and this guy is reminding me, he's not making an offense. This is a justification. And now the issues of law, probably some people do not even know. Some people would not think you can discuss anything around the general court-martial. But now it has come out the public. So the public wants to hear, what did the Supreme Court say? Has it been effected? So for us coming out to amend, because the court-martial was provided for in Parliament.
Okay.
So it still goes back to Parliament to do that.
Mr. Simwe, when you hear members of Parliament of the NRM are going to caucus tomorrow on this very issue, what are your fears? What are your concerns?
Our concerns are, basic. One, we worry that there's a likelihood of using this as an opportunity to the question you've been asking, and they're going to come up with ideas that are going to be contradictory with the Supreme Court ruling. But again, when you look at the way things are moving, the way these people who are being held in prisons from the court-martial, that they are not being prepared, they're not being, they're not being released. So our worry is they are rushing to amend the law and use that same law to keep them on to these people, to keep them in prison. That is our worry. And our call really is that shouldn't happen. We've been making this call that let whichever the powers be, they should respect the Supreme Court, decision. It unequivocally stated that civilians should never at any one point be tried in the military court-martial. And this has not only been in Uganda. I think Uganda were far behind. If you look at so many other jurisdictions, they've gone off from that. Go to other nations, Venezuela, look at South Africa, recently in the UK, Colombia. They have been very clear, and whereas we need that discipline of the army, because I'm not saying we shouldn't have a disciplined army, but when you look at the purpose of creation of the military tribunals, actually refer to them as tribunals, not courts. It is even wrong to refer to it as a court because it does not fit within the tenets of what a court should be. But it's a military tribunal, meaning it's a specialized way to handle those disciplinary measures. In
the execution of their duties.
Exactly. I would have no problem if it is created for that purpose, if they are serving officers who are within the course of their duty, in execution of their duty, they have discipline cases, discipline issues, then they should be tried in that particular military tribunal. But it is wrong to try and bring it within the ambits of the courts of law, where there's a serious likelihood of abuse, where people will be brought in that court. And if you heard properly, it doesn't mean by that serving officers are not entitled to certain rights, like a proper hearing before a competent court with competent judicial officers. That is why you had some of the judicial officers, some of the justices of the Supreme Court being very clear on, I think it should have been Justice Wamgemerire in her judgment. She was very clear that even if someone is a serving officer and they commit an offense, probably it's not a service offense. So now that's where we go into the deeper aspect of which offenses or what kind of disciplinary actions should be, the disciplinary issue should be handled through that tribunal. And by that, also talked about the sentences, like stripping you off of your rank, like maybe sending you on suspension. Those are some of the, of the punishments. But if you're going to legislate and you're looking for punishments that are penal in a way, that someone, you look at sentences they give, 50 years, 40 years, those are sentences. Even when you go to the normal procedure, others are given death sentences. These are sentences that must be confirmed. If a death sentence is passed, it must be confirmed by the highest court in the land. But now if you have this which is not in the hierarchy of the court, as far as Article 126 is concerned, and then you're giving them power to try individuals, be it a civilian or not a civilian, those people, if they're serving officers, they also have
when you caucus tomorrow, there have been utterances made by senior military officers in the country about this case. And in fact, I remember one was saying Dr. Besigye should be hung, Dr. Besigye should come out kneeling and apologize. How deep do you go in trying to discuss some of these issues? Because at some point they may look very trivial.
Patrick, in the caucus, we don't discuss institutions. As members of parliament who are going to caucus within the party, we may not discuss. Probably if I would be here and you came to the Committee of Defense, you would ask me as a member of the Committee of Defense. So we will not actually go into that. But let us have hope. Because like Council tells you, punishment, I don't think we shall even go that far. And I told you we want to respect. And if we would just only say, okay, the Supreme Court has pronounced itself, why can't we look into this law and dig out all the things that Council is saying? Because it's within our mandate as Parliament to do that. So to discuss who has made this statement or what, now that may not be a very factor now, because we shall not look at that. We shall not make a law that in reference to so and so who made these statements. Now, let us have the law and let us work on implementation and respect.
Well, I know you may not have to discuss some of those statements, but do you understand as a leader that somebody in high positions of authority can make such a very reckless statement and the Parliament of Uganda is silent about it?
I told you we don't supervise. There is UPDF, there is a commander-in-chief. So as a member of Parliament, it will be running out of our mandate to do that. If we want to speak in that language, that person, we have ways to do that. We can summon, depending on which committee that supervises that agency, that person will appear and answer that. So I don't even want to waste time to think about that. I want to think positively on how this law will effectively uplift the rights of Ugandans.
Is the institution of Parliament an institution that is free to execute its mandate, or it's another sort of captured institution that may not work freely?
Patrick, Parliament is one of the arm of government. If me and Council here are MPs and we are the Speaker, we make a law that all men tomorrow should kneel for their wives, it will. That's how strong it is. So it's a very independent body and the other arm of government. So we do make recommendations sometimes. We have committees that are actually at a level of a high court. That's why even yesterday we put some Chinese on oath. I've been in a committee where we've put officers or PS on oath to make sure that what they say goes on record and is nothing but the truth. So that's a very independent body, and we do. Because I wouldn't want to associate my brains to an institution that is not independent.
Well, you speak for it, and I wasn't.
I don't speak for Parliament.
You speak for the caucus, and the caucus is almost entirely Parliament. Anyway, so when you were going to caucus, I just want to know, is the chairman who calls for the meeting, and is it even often that the caucus can go against what the chairman, the wishes of the chairman?
The caucus, any caucus, I'll speak about the NRM, is a party, and we have structures, rightly from the national level up to the grassroots. So the chair, now the chair of the caucus in Parliament is the government chief whip. The national chair is the president. Now, under the guidance or in consultation with the national chair, we can have such an extra, because this is an extraordinary caucus. We have our monthly caucuses every first
An idea of
Friday.
the national chairman.
Of course, this is a public, we shouldn't run away. Some people are saying you shouldn't talk about it now. No, this is in the public domain. So we normally have our caucuses that are called by the chairperson, who is the government chief whip, and we check ourselves. We check out on our leadership of committees, how is the performance? How far have we gone with the government program in Parliament? So now this is in consultation with the national chair. And he is also the commander-in-chief. So when you talk about the general court marshal, and he's a retired soldier, he has well knowledge. We want also to put these questions across. Actually, this is like also a consultative meeting, where I think, I would assume that the law council was called, the rich people, legal rich minds were called, other religious leaders. The same thing we are with the marriage bill. We've been calling all these church leaders. So this consultative meeting with the chairman, who is also general, and I think we want also to know who constitutes the general court martial. So it's going to be a very good conversation. I would interest you that at about 5 o'clock we shall be out there and we shall tell you the resolution. But that will not be the binding. We still have to come back on the floor of Parliament and legislate.
Well, I hope it's going to be a vibrant and free thinking kind of conversation, like you're saying, because in most cases,
Patrick, I do the way you moderate here. I do moderate the caucus, and I don't even know where people get ideas that NRM MPs don't talk. We spend 2 hours. The chairman communicates, and then members bring ideas. We just even stop. The last caucus we went up to 8 o'clock because ideally everyone wanted to say something, and it was very contrasting.
May I remind you that your true bosses are the people of Kagoma North?
Yeah, of course.
You were voted into office not because of the caucus, but by Kagoma North.
Do you know how much
Kagoma is listening and Kagoma is watching?
Do you know how much the Kagoma people are proud that their constituency is often talked about? Because you introduced me as a member of Parliament from Kagoma. Yeah, but did you ever know about Kagoma before I came?
The thing is,
so that's also pride for them.
The thing is, sometimes, with all respect, members of Parliament forget that their true bosses is the constituency that voted them to power, not even a caucus, a speaker, or a president.
But when you look at me, I'm a young man, so my memory is still very pure. I cannot easily forget. And I have a very great background of the seminary where it only takes the best. So the people of Kagoma who are watching, actually they are even watching, and they are giving me kudos. They say, we are proud. Because I don't only legislate for Kagoma, I'm a national leader. And to me, it would also be good that I've been discussing with council out there, that before I became an MP, I wanted to be at a policy level formulation. Now I've gotten a chance to participate into this, making a law.
So, Mr. Anthony Simwe, it's not only Dr. Kizza Besigye who is affecting this. There are very many other people. In fact, NUPO has profiled about 46 people, members of their party, who have been in court-martial. And sometimes we can forget that it's more than who? It's more than Dr. Besigye. Exactly. Do you have an idea how many people we're talking about who could be facing court-martial? And some of these names have even been forgotten.
Recently, immediately after the ruling, we at the Uganda Law Society took measures to look out for people, especially those who do not have people who can speak for them. And we immediately took steps to begin, registering and looking for people through our various, offices, the legal aid offices across the country. Patrick, I can assure you, within a week, we just had, substantive lists. We are still compiling, but I can assure there are thousands and thousands. The biggest number being from Karamoja.
You have actually represented people in Karamoja.
Yes, we have.
And some people have said the court-martial has been so good in pacifying Karamoja.
And you see, that is subjective, because the challenge is what kind of trials, especially for the civilians. The civilians are being taken to that court. You can imagine there are some trials that were so terrible. A file which has 60 people, they're being tried summarily in 3 hours, they're sentenced, given 40 years, 50 years, without a fair hearing, a fair trial, as enshrined in the Constitution. Now, the numbers are so big, they're so huge, we are still compiling. Unfortunately, like you're saying, it's only those names that are known, the people you know. There are those who are unheard of, their families don't even know where they are, but they are in that system of a court-martial. And that's what we are saying, that why did the Supreme Court not give a clear structure? Who is going to follow up on those people? Who's going to ensure that these people get justice? Now, these delays you're seeing, the system or what is happening after that is exactly what we anticipated, and this is what we talked about. It is so absurd that even after getting this kind of relief, which you felt was a relief, you still have to go through another hassle, another battle to look for these people.
Can Parliament override a court decision through legislation?
Now, Parliament, and this should be a warning, should never ever pass a law that overrides a court decision, especially the Supreme Court pronunciation, because that is now the Supreme Court ruling is on the law books. It is precedent. So court sets precedent, Parliament makes laws, but Parliament should at all points, every time, avoid making legislation that overturns or coincides or contradicts a decision of court, especially the Supreme Court. So as my honorable speaking here, I had him assure us that they will make sure this doesn't happen.
And it cannot.
My worry is, how are they going to safeguard against this? And the only way is maybe, like he stated, if they can be honest enough to seek the guidance of the legal brains or the people who can guide in this process, and also try not to use it to abuse people's rights or create an even bigger problem.
The fear, Honorable Brandon, is that any amendment that can come through Parliament can easily get weaponized to target, opposition or activists against government. And you could be in government today and you are an opposition activist tomorrow.
That's actually a very wrong mindset. And we have it in Uganda. I used to have it as well. Parliament, we stand. I remember in the Public Management Act, one of the framers was affected. He was trying to cross, to go to, just here the bridge near. He was not even allowed to cross into my kingdom. Just a young officer told him, please, sir, turn back, and this is the law. So I think, and as a politician, like I told you, we are all candidates, save probably for council, but I know you're also a political man. You have interest, I would love to see you in one of the parliaments here. So I don't want Ugandans to have that bias. We can caucus, and that parliament we have been standing together. Like talking about the Supreme, we have not, it's entrenched within the Constitution. We cannot. That's why we are rushing to make sure we respect the decision of the Supreme Court.
How free is the caucus from the whims and the wishes of the chairman?
We are extremely very free and interactive. How free, I don't know the magnitude you want me to explain, but look at the coffee conversation. Look at the Penetti conversation, where Penetti and everyone was like the NRM MPs, and we stopped it. So these are laws that are going to be, this is, you know, when I'm taking an oath on the steps of Parliament, I swear to protect and defend the Constitution. So people should stop thinking that the NRM MPs, when they go, they will just be, we are free, and some of us have no program of going away from this country. So I want to assure you, from today onwards, just to know, build confidence and have trust and have hope.
Anthony, what does the Constitution say on legislating on matters of Supreme Court?
Like I said, legislature or the Parliament, while legislating or coming up with laws, whichever, especially in this matter of coming up with amendments to a law, it should, as much as possible, avoid coming up with legislation that contradicts the position of the law. One thing you need to know is that the courts, especially the Supreme Court, sets precedent which should be respected throughout, and all those are the considerations they should have in place. Of course, we should also not forget, he talked about separation of powers, where the judiciary, is an arm of government, should be independent, should not be influenced by the legislature, should not be influenced by the executive. But there are certain parameters of particular principles when it comes to legislative drafting. What should be the considerations? Are you coming up with a law? Of course, now when you look at the Constitution, or when you look at the Supreme Court, the nature of the decision we have, for example, is based on constitutional interpretation. The Constitution is the grand norm. Parliament, in the first place, shouldn't come up with any law that contradicts the provision of a Constitution. Actually, the guiding principle should be the Constitution. Now, we have a Supreme Court which has made a pronunciation, an interpretation of the Constitution. So even when coming up with these laws, you must respect that particular interpretation of the Constitution, because it is actually what should be the guiding principle.
You know, when you look at the Supreme Court ruling, somehow it lacked that clarity on the people who are being tried, on whether they can actually go free or not. That it's ambiguous. And was that intended?
We want to believe that the Supreme Court, in all the the good things they did, being very clear that civilians shouldn't be tried, when it comes to the orders given, that's why now we have a challenge on that lack of clarity, which is bringing up this confusion we're having right now. You just heard recently that DPP is taking over files. Now, it's also such a process. What is the procedure? How can DPP take over files from court martial? They're already telling us that these courts were illegally in place. The people are not supposed to be in those courts, and it's such a process. So to answer your question on whether it was intentional, I believe probably the Supreme Court was trying to balance, because it's an issue of what are you giving the people and how are you being looked at. And I was thinking, why we've had so many laws, so many decisions that have come up, and we've had so many legislations which have been pending even in Parliament for so many years. I'll give you an example of the National Legal Aid Law. It's been here for years, but what is so important? What is that, that very important aspect that they even have to call for a special, sitting? This is so urgent, we cannot leave it. And these people are still in prison. They're still in custody illegally. Why do we need to get, the moment court passes a decision and we have debates on what that decision means, or what the implication of that is on how to implement. Yesterday, when we were following up on the Kizza Besigye issue, you had what happened in court, where people are saying, okay, someone extracted a decree, it was not very clear. Now, that causes, it leads to injustices.
Okay, Honorable Brandon Kintu, today, when you see what is happening in Uganda, you as a legislator should be even more concerned because, look, I want to bring out the case of a lady called Masiwa Lukamba. These are some of the members of the Electoral Committee of National Unity Platform. They are coming from a barrio somewhere in Mpigi. They are kidnapped. And you could see their family members crying on TV, giving interview. They don't know where they are. Fred Sentamu, brother to the Honorable Robert Chaplain, the Chairman Nyanzi, arrested somewhere in Kobiri in a violent manner and taken. And then you wonder, why? Because they are arrested by people who are armed, and you could say they are not thugs. This is government.
Actually, you have mentioned a very nice word, because during the day, people are talking about abduction, kidnapped, and the spokesperson of government today pronounced himself that those people were arrested. So I cannot start analyzing the arrest, because once government arrests, but what I heard from the spokesperson of government, the Honorable Dr. Wariomo, says that they watched Chairman Nyanzi commanding a certain group. And he says it was patriotism. And some statements were made that they have on record. So they arrested them to investigate. Though I still also condemn the nature of arrest. We have been cautioning these men and women in uniform. The other day I saw the Women League of the FDC also in the market. And I think that was somehow in the start decent, because these men were fearing to combat with the ladies till they waited for the officers. So, but we still have to condemn and caution. Because if those people are just called, get in the car, you made these statements, come and tell us. And it's also wrong that somebody can be found after 3 or 4 days. Because it was today that government came out and said, we arrested them and we have them. So for further, how do I take about that? If it was criminal, then we wait for the investigation.
Yeah, the modus operandi is so wrong because it pretends that the government is acting in a manner. When you see what is happening, hooliganism could be another thing. You could actually, you wonder, with all the state authority, you could summon this person. He comes to wherever you want them to go, and then question them. And you have the case, if they lose the case, let them go and serve. But you do not act in a manner that is more or less like hooliganism.
I think I am not an expert in security. I just see things as well. But issues of governance, when there is government, Patrick, if you made a statement here, Kampala can catch fire. Now. You can just make one statement. So, if you are inciting and then they come for you, probably the arrest, we should also question the nature of these people arresting. These police officers, have they been trained in human rights? And that's why we have appropriated money in police to train these police officers who are going to carry out the conduction of elections, so they can also be able to respect and defend what they know. So those acts, we say we shall continue. As a legislator, we are concerned, and I think in our Committee of Defense after, we have already written the IGP, we want to know those people and question this act. And I'm sure the Minister of Internal Affairs will come up with a statement. You
see, whereas Chairman Nyanzi can be arrested and maybe the spokesperson of government can come out and say, because we are talking about a high name recognition, there are quite a number of people who just, you fizzle out. Nobody knows where you are, but the state tells you. For example, there's a very famous case of a man called John Bosco Kibalama. At one point, even the government said we have him. But John Bosco Kibalama, it's more than 5 years and has never returned, not even in court, not anywhere.
I think also, Patrick, you are aware you have sources how to address this. It's like me now asking the president about the caucus. You know, there is always a press briefing here at the media center. Who are your neighbors? You can raise this concern. I would also be interested to know if they can explain that. But I'm just restricted on the caucus issues because that's where I understand. But I also, as a legislator, I told you.
You've just been saying
as a legislator.
Don't step away from the role. You've just been stating you're a national leader.
Yes,
and because of that,
and I have
putting you questions
and I have
of national nature.
And I have a fora. Now let me interest you and give you hope that I'll raise that on the floor. We have that space of issues of national independence. And as a legislator, I'll raise that. And I told you I have another avenue in the committee where these agencies, we can supervise and oversee them, their work. So I want to promise you we have put up, we have come up, and we can come up with recommendations as Parliament.
So as a lawyer, you know, representing some of these people, maybe defending their rights, have you not reached a level where you think in the case of Dr. Besigye, you have done everything that there is to do legally?
Patrick, you're very right. And when some people see what we've been doing at the Uganda Society, people are referring to it as banging tables. It's because you reach a point and realize you've done everything you're supposed to do. There are procedures. You followed every procedure. You've taken every step. But you still can't get a remedy for someone for, you know, unclear reasons. You see someone like Kizza Besigye in his state, where you believe what the judicial officer should have considered is the man's health, the condition, and then you say, no, let the guy go back to prison. It becomes so frustrating for legal practitioners where these clients have a lot of hope in you. Someone comes down, they're expecting a remedy, and you use every source, every kind of procedure there is in the law books, but you still don't get a remedy, and there's no clear explanation for that. There's no certainty in practice anymore. Some lawyers even fear to take some of these clients or these instructions, because you know the client is going to instruct you, you'll go to court, a scenario like Besigye's, and you cannot assure the client that your person is going home or this person is going to get the remedy, but you followed every kind of procedure. So it becomes so frustrating. And again, as a nation, there are certain things that we call humanity. We are all human beings. Now, whereas the judicial officer is seated at the other side, I heard you earlier ask, I think, Honorable, about issues of interference or, you know, independence. If you remember, one of the reasons the court was giving for the likelihood of not having a proper fair trial in the court-martial, military court-martial, was because it was very clear that they can never have judicial independence. There's always going to be interference. There's always going to be someone else who wants a particular order, interference from the executive, from the commander-in-chief, because they're heads of the court. But now, if you reach a point where, even in the normal courts, the judicial officer is not going to give a decision, a proper decision, because there is that, you know, clear or unclear interference, or they lack that independence, realize there's no independence. Someone is acting out of, you know, some other forces behind. It is so absurd. And that's why it makes it so hard for anyone, even legal practitioners, to practice in that kind of field. But the lawyers turn out to be more of activists in this scenario, because you've done the legal work, you've tried the legal proceedings,
you have
they've
exhausted
not worked.
All the channels.
So the only option now is becoming an activist. So that's why I see most lawyers will now appear like activists. They're now, you know, advocating. They're doing advocacy, not the normal advocacy of practice, but looking for other means, other ways of how we can actually get a solution for this person. And we've actually adopted that at the Uganda Law Society. We felt like, okay, now we also need to add the pressure, because if the normal channels are not working, you're going to file all the applications, the person will come to court, but you will not get a result. They are sending the person back. So what is plan A, what is plan B? What can you do to get a remedy for this person?
It must be very hard to be an officer of court in Uganda today.
Extremely hard.
Mr. Simon Anthony and Honorable Brandon Kintu. Gentlemen, we're going to take a break. On the spot, we'll be right back. Welcome back. You're watching On the Spot. My name is Patrick Amara. My guests tonight are Honorable Brandon Kintu, Member of Parliament representing Kagoma North, also spokesperson of the NRM Caucus in Parliament. And I also have the Vice President of Uganda Law Society, Mr. Simon Anthony. You know, it is very uncommon, Honorable Kintu, for the caucus to sit 2 times or 3 times in less than 2 weeks.
Our constitution of the NRM Caucus mandates us that if there is anything, whether joyful or sorrowful, but for as long as it needs an urgent attention, we caucus. So we have not breached any law within.
This is very urgent.
We had a resolution that we meet every first Friday of the month. We just had a caucus meeting. And we agreed. Actually, this caucus has not just come. We agreed. We made a resolution that as we work on the process of withdrawing the bill, let us recaucus and reflect and understand and protect the decision of the Supreme Court. So it's within our law and within our constitution.
Now, talk about the constitution. What would be the repercussions of the caucus sitting in Entebbe or wherever they're going to sit and then coming back to Parliament and then have a legislation that will sort of change the Supreme Court ruling?
That would be absurd, and of course it would face stiff challenges and constitutional petitions all over. And it will really be of no use because you can't have two parallel laws. Remember, when decisions are being made in court, they will cite provisions of the law. And again, this ruling having come before, you cannot, like I said earlier, and you come up with a law and amendment that is aimed at, overtaking or somehow changing the decision of the Supreme Court. It will bring some kind of absurdity in our legal regime and in the country. So it will never even get to be applied anyway, because you'll find, you'll see so many constitutional petitions here, people challenging that kind of legislation in one or another.
So in the caucus meeting, sometimes, Honorable Kintu, reach a level where some colleagues actually totally disagree and then maybe things are reached at a vote? Or
it's a meeting. So when you're chairing a meeting, you must be able to accommodate. And if it wasn't a meeting, we would come up with maybe commands. That's why we resolve. And when we make a resolution, the chair now of the caucus, not the party chair, who is the government chief whip, will read and say, members, is this what we agreed on? And we'll put a question. So if we've not agreed, there'll be some nays, and then we shall have to amend. So we interact, we give ideas, and this is it's one of the most democratic process within the NRM.
What kind of position do you go with in this caucus tomorrow, as for you, Honorable Kintu?
Well, we got a notice of this caucus when we already know. First of all, we are going to listen, because we are interested. This is what we recommended, that in our next extraordinary caucus, we need to have this bill. So we shall have now whoever is concerned in the legal mind, the ministers will read one by one, and we shall be asking if there are big terms, like I know of one land friend in this country that uses big terms, we shall put a question that can you help us simplify to understand. So the position is we must appreciate, but in respect and line with the Supreme Court judgment.
At your own level as the spokesperson of the caucus, did the Supreme Court, take the right chord for you when it decided to say civilians should not be tried in the military court?
I think even my son Ryan, who is 4 and goes to Taiba, would understand that. So it's in good spirit, extremely good spirit. And the Supreme Court is the highest court, Patrick. It's the highest. The other court would be heaven, but I don't think we shall go and legislate.
Why would a caucus want to tinker with something?
We are not tinkering, we are respecting. We are actually, we are celebrating that this court has shown us.
You're going to celebrate the Supreme Court ruling.
This court has shown us that we should appreciate freedoms and human rights, and this is what is supposed to be. Guidance is very important in any governance. And that's why Council told you, this is another arm. They may work together, but we have to respect the separation of powers. Judiciary is a competent arm. 3 of them, I'm lucky I sit in one. I'm
tempted to open the line, so at least like 1 or 2 people, you Ugandans who are watching this, and so that you can also have your say. You're going to see the number on the screen. Tell us what you think, a question or a comment, or perhaps a message you want to give to the spokesperson of the caucus who will be caucusing tomorrow. What message do you have for him? What question do you have for him? What comment do you have for him? Pick up your...
And also for the Vice President.
For the Vice President of the Uganda Law Society, the legal rebels. What kind of question do you have for them? And I know in situations like these, you could be maybe disagreeing with the spokesperson of the caucus, which is okay. But remember on this platform to disagree with respect. And you tell us your name and where you're calling from. and keep it very brief so that we can have maybe 2 or 3 people make a contribution. Before we took a break, I was saying it must be very challenging to be an officer of court, to be a lawyer, because it appears now we are trying to normalize what is abnormal. How do you...
You know, if before we came in, Patrick, I was discussing with the Honorable, and he was telling me about how he's recently come to know about the ULS and the radical new bar. This radicalism you're seeing, this banging with the tables you're seeing, it's things are being done, you know, differently because members, lawyers, legal practitioners realize that the normal doesn't bring results. There are so many challenges that that are being faced. There are so many challenges that are in the, you know, in the judicial sector and access to justice. Recently, you've seen a lot of bickering and exchanges and fights at the expense of beneficiaries. People should be benefiting from this, you know, from the justice sector. Now, you realize that, like I said earlier, in your practice, you cannot get a result. You cannot go to court and assure a client that I'm going to get this result for you. We followed every procedure. But then again, you have, I'm not saying every judicial officer, but some judicial officers, on the other hand, are going to tell you, I cannot act, I need to get, they act on a phone call. Orders from above. We have a lot of corruption in the system. We have a lot of incompetence. We have a lot of people are not independent-minded, who do not follow the basic principles, like what should you consider first? If someone's particular rights are at stake, a right to life, a right to health, what should you consider first? Should you now consider the politics? Should you consider the orders from above before you actually, you know, these people take judicial oath. There's a judicial oath. It's very important, but I think people on the other side at the bench tend to forget when they reach there, they sit and they become comfortable. That is why we are taking the approach.
We're always hearing something called the cadre judges and something like that. Yeah. You have to deal with some of these people. With all respect, is this just mere talk of cadre judges, or do you sometimes have to find yourself presenting before a cadre judge?
You know, it's...
is that also your title, the judges?
No, the judges you go to, judicial officers you go to, and you almost know what the decision is going to be because of that, you know, the cadre judges you're talking about. You've had our fight with when we want to democratize the Judicial Service Commission, which has the power to appoint, to guide or to support the president in appointing judicial officers. But as the Ugandan Society, we usually have 2 representatives there. And in the past, all these years, Ugandan Society has never gone through a democratic process to select those people. So one of why we chose to say, no, let's go through a democratic process and have the members, the 6,000 members, choose which people should be sent to the Judicial Service Commission. It was aimed at cleaning up the judiciary, so that the appointment of judicial officers is taken very serious because they hold a very important office, to avoid those, you know, these cadre judges. Of course, I know at the end of the day, the appointing authority is one you might give names and maybe is not comfortable, but at least we'll have had a transparent process, a transparent system where people...
You have given a certain a pool from where you can choose.
Exactly, where the members participate transparently and say, you know, this is the best person to be in that office, other than seeing appointments which are really, you know, questionable. The people who are not competent, people are not, whose integrity is in question.
So, but if there is the involvement of the Judicial Service Commission, which also you have membership in that commission, where the president picks names from those that have been presented before him, then really the issues of cadre judges shouldn't be arising.
Yeah, that's what we believe, because they say the president is supposed to select based on the recommendation of the Judicial Service Commission, which we believe if they have a transparent way of selecting, they have competent people that have been sent to the president works on advice of these people. We avoid such challenges where we have cadre judges where, you know, this one is going to make this decision, and that's exactly what you get.
All right. Gentlemen, I want to thank you so much. Looks like I'm having a ticket hitch for people to reach you, but I'm going to give you, each one of you, a minute or 2 to give us your concluding remarks, beginning with you, Honorable Brandon Kintu.
I only call upon the citizens to trust, have hope and confidence in your members of parliament, and we shall bring the best.
Thank you. Mr. Simwe, your concluding remark.
All right, thank you. My concluding remarks is to remind the Ugandans, the people in power, our members of parliament who are going for this caucus, that it is important to observe the provisions of the Constitution, the human rights. It is more important than anything else. So whatever decisions are being made, let us be reminded that the respect of human rights should come first before anything else.
Mr. Asimwe Anthony, Vice President, Uganda Law Society, thank you so much for having honored the invitation. Thank you so much for adding value to this platform, and thank you for your submissions. Honorable Brandon Kintu, Member of Parliament representing Kagoma North and spokesperson.
On the NRM ticket, because the people of Kagoma voted me on the NRM ticket.
Somebody, by the way, somebody said here, whom I can't say the name, that you are executing, you are elected by the people of Kagoma on an NRM manifesto.
Exactly.
I always wanted to remind members of Parliament where I come from. For example, my MP, Honorable Donald Kataliwa, who is also my brother, that please remember when you go to that caucus, it's we, the people of Mwenge South, that elected you, and we who can elect you again or maybe not. So we are the bosses and not anybody else. I hope that also pertains to the same for every member of Parliament. Always remember your constituents. I suppose that would be the best, because they are the guys who give you the mandate. Gentlemen, I want to thank you so much for the time you've given us, and this brings us to the end of tonight's edition of On the Spot. Join us again next week, same time, same place. And for those of you who have been watching this program, I want to thank you for the privilege of your company. Good night and God bless Uganda.